could be floating around you right now, and you can't see it. You can hardly smell it. And by the time someone's diagnosed with cancer, all the important evidence is years old. Today, we're going to talk about ethylene oxide, some of the recent litigation in Florida, in places like Tampa and Fort Myers, and elsewhere around the country, and why the details really matter. It's not just a circle around these facilities. Wind plays a huge role, something called building downwash, HVAC systems, and many others. And cancers too. Only certain very specific types of cancers have been scientifically linked to this chemical. And then we're going to connect what's going on here in Florida with other major settlements in cases that have gone on in Illinois, Georgia, and elsewhere, and why Florida could be the next boom of ETO litigation. Let's start with the part that no one should skip. Ethylene oxide is not just some random chemical. It has a very important and practical use. It's used to sterilize medical equipment, things we use every day in hospitals. The problem is some of this equipment can't be sterilized through methods like steam. It would damage it. So ethylene oxide is one of those chemicals that can be used to make sure there's no harmful bacteria and other things on this equipment. Think about catheters, surgical kits, gowns, drapes, pacemakers, stents, ventilators, syringes, devices with plastic, packaging layers, tiny, hard to reach places. All these things used in the medical field have to be sterilized. Ethylene oxide, because of its chemical nature, it's highly reactive. It means it can damage DNA. It is carcinogenic according to the EPA, especially when inhaled. So the story, of course, is not medical devices are bad, sterilizing medical devices is bad. That's not it. The story is when a life-saving industrial process also happens to be carcinogenic, then the safety has to be excellent. The emissions have to be controlled. The monitoring has to be in place, and the nearby community has to know what they're breathing. Because if the controls are weak, delayed, poorly maintained, bypassed, or altogether not even working, then what's going on here? Then the benefit all goes to the medical industry, which is great, but then all the risk gets absorbed by unknowing, innocent neighbors. The danger is shifted to the people who live, work, go to daycare nearby. Workers, neighbors, schools, people who work and live in hotels. They sleep there. They never consented to this risk, to this danger. They're not getting paid for it. ETO cases are not just chemistry cases. It's not just asking what happened, what was the chemical, does someone have cancer? It's about reconstructing the entire exposure path. How did this happen? You've heard about accident reconstruction? Yeah, that's a complex area, right? Well, think about something that's invisible. It's floating around in the air in the past, and we're trying to reconstruct how individual little chemicals, where they went, how likely is it they went to certain places, and how long were they hanging out there. So a lawyer is not just asking, is a chemical carcinogenic? A lawyer is asking very specific questions. Where was the facility? How many years did it operate? How much ETO was used? How much was emitted? From which air vents? At what height was the chimney or exhaust pipe that emitted the chemical? How fast was the chemical going when it left the facility? There's little exhaust fans in these systems. They can go faster or slower. What buildings were close by? Were those buildings taller than the facility that was emitting the chemical, or shorter? That can affect the way the air swirls around that building. What were the wind conditions, typically in that area? Do we have wind conditions on an individual basis, day by day, so we can connect them to the production of ETO on a given day, in a given week, on a given month, in a given year? Toward which way did the receptors, which is sort of a word that's cold to think about, the people who are working nearby, the people who are going to school nearby, who are living nearby, the kids who are going to daycare nearby, the people sleeping in hotels nearby. Where is the chemical going as it gets out into the air around the facility in that neighborhood? Who lived or worked in these places? How many hours a day? How many years did they live, work, go to school, sleep there? What kind of cancer were they ultimately diagnosed with? What was the diagnosis date? Are there other risk factors? that may have caused cancer besides the ETO? And what's the latency period of that cancer? That's the case. Ethylene oxide was first identified in a laboratory in 1859 by a chemist named Charles Adolph Wurtz. By 1914, it was being used in industrial processes. In 1931, however, there was a big breakthrough. It became a lot more efficient to make ethylene oxide, and later in the 1930s, its sterilizing properties were discovered. So it actually could be used for sterilizing equipment, including medical equipment. Fast forward 50 years to the late 1970s, early 1980s, where we start to realize, by virtue of animal studies, by virtue of studies of employees who work around these chemicals, that ethylene oxide damages DNA. That can cause cancer, blood cancers, breast cancer. And so it became a concern by NIOSH, the National Institute of Occupational Safety and Health here in the US, that employees who were exposed to ethylene oxide could end up with cancer. And so by 1984, we had a rule that was implemented by the United States for employees that would limit their exposure to ethylene oxide, and companies had to take special precautions for employees, because at that point it became clear for employees who were working around this stuff every day in close proximity that ethylene oxide was a concern. But then we wait all the way until 2016 until we have definitive data on how this chemical, when it's released by a certain, facility, that it could affect the community at large, even in small diluted amounts. Release any kind of gas or smoke out of your house, obviously gets diluted by the atmosphere. Well, apparently, in 2016, the EPA discovered in those small amounts, it could still have a negative effect on community members that live nearby. Now you ask how nearby? We'll talk about that later, but within a couple miles typically. That study in 2016 showed that the risk of cancer, a very specific type of cancers, for these folks who live nearby or work nearby or go to school nearby is greatly elevated. And so that became a concern. So EPA started notifying people who live near these sterilizing facilities to tell them about what's going on. But not until 2024 do we actually get a rule where it clamped down on some of these commercial medical device sterilizing facilities to make them do a better job of filtering out the ethylene oxide before it's released into the air to affect the community. 8 years had to go by before that happened. And now get this, we're sitting here in 2026, and now there's a concerted effort to reduce that rule that was just entered 2 years ago, because the concern is that we're hurting the medical supply industry. My goodness. I'm being a little over the top there, but I just want to make the point that if a chemical is causing cancer, then the business who's using that chemical to do an important job, by the way, sterilizing medical devices, has to understand they got to bear some of that risk and take on some of the financial burden of making sure they're not affecting the nearby communities. Because now we have a situation where we know since the 1970s at least that it was causing cancer in animals, that it can cause certain types of cancers in human. Then we have to wait until 2016 to get definitive data on how it affects the nearby community. People who don't even realize in many cases that there's a sterilizing plant that releasing a cancer-causing chemical into the air. And now, 10 years after that, after we finally got a rule to really limit the amount of cancer-causing chemical being released into our communities, that we're trying to claw back that rule for financial reasons? Come on. And by the way, you're gonna get this, 2026 commentary came out to reduce that rule. The commentary says, hey, by the way, there may be health disbenefits from reducing the protections of a 2024 rule. Health disbenefits. You know what that means? That means more people are going to get cancer. Part, my friends, where it's okay to be outraged. Not hysterical, not assuming facts that we don't know, but legitimately outraged.
I'm as mad as hell, and I'm not going to take this anymore!
Because most of us live in a world where we operate things. We own our own business, or at work, we own whatever part of the business we're in charge of. Barbers, accountants, lawyers, landscapers, you name it, you know what you do the work. And if something affects your business, some kind of big news, either internally or in the public, you're aware, right? If you're a college football coach and some news comes out about NIL, You knew what's going on. If you're a teacher and your union might go on strike, yeah, you knew what's going on. So to tell me that some of these companies producing ethylene oxide did not know how dangerous it was to the community at large after 2016 or maybe even before, and they took years and years to add scrubbers or filtration, maybe the CEO was not reading every technical report, but the company had lawyers. The company had safety people. The company had an engineering team. The company had a facilities team. They have consultants. They have compliance people. They have people whose whole world and whole jobs are to make sure they're doing things correctly and compliant. They have people whose whole job is to know when the science, the regulation, and the risk picture changes. And that is why the information released by the EPA in 2016, 10 years ago, matters so much. When that document from the EPA essentially says, hey, this stuff's a lot more dangerous when people breathe it in over time, the response should be urgency. Not 7 years of waiting, not public relations framing, let's see how many holes we can poke in the science, but urgency. Now, to be clear here, I have no idea what happened inside the boardroom in these companies, the legal department, the engineering meetings, what their consultants are telling them. We don't know any of that right now. Discovery, which is the process in court cases, in litigation, where the other company has to turn over their internal documents, that will illuminate us into what they knew, when they knew it, and what actions they decided to take at the time. But cases like this, generally, the way some other big corporations have acted, instead of saying, hey, let's get our house in order, let's start capturing these emissions, let's start measuring the air, let's warn people nearby within a certain radius that are close to our facility. Instead of doing all that, typically the playbook is something else entirely. Oh, how do we challenge the science that the EPA is coming up with? Or how do we delay, as long as we possibly can, these expensive controls that we might have to implement to capture these cancer-causing emissions from going out into the neighborhood air? That's instead of saying, hey, let's get our house in order. Let's start capturing these emissions. Let's start warning people about it. Let's see what we can do to efficiently and financially responsibly capture the emissions so that we're not putting our business at risk, but so also, more importantly, we're not putting people at risk that live a mile down the road or 30 feet away across the street. But no, instead, what you see oftentimes is how do we challenge the science? How do we make the EPA's findings less authoritative? How do we go as long as we can without having to do anything? I don't know if they did it here, but that's what they do. Because they're thinking about saving money. And again, that's their job, to save money. Nothing wrong with saving money. Where the problem is, when you're saving money, and meanwhile, somebody's mom across the street may get cancer 10 years from now because you felt like you wanted to save money. And so somebody's mom might be in their deathbed 12 years from now with their kids watching them take their last breath because you wanted to save some money. Now, let's get to the part that most people skip. How close do you have to live to this facility, or worked near the facility, or went to the school near the facility, or otherwise spent a great deal of time near the facility for it to possibly have affected you and even contributed to your cancer? It sounds like a simple radius question. Was I within 1 mile, half a mile, 3 miles, 5 miles, 10 miles? But in air cases, because again, this is an air pollutant, it's inhaled by the affected individuals, it's being, spit out of the building or leaks out of the building through the air, invisible. It's not always a perfect radius. You can't just draw a circle around the facility and expect to see if you're in that circle. Now, sometimes it works out that way depending on how the wind is, prevailing in that area. But usually there's some deformities to the circle. Areas perhaps to the southeast more affected than the northwest, for instance. So distance, how far you lived, worked, went to school, your child went to daycare from an ETO facility is going to be probably the first question an attorney asks you, aside from your diagnosis, because it's very important. And when I say distance, I actually mean distance as the crow flies, from your school, your home, your workplace, to daycare, to the ETO facility. So if you or a loved one has been afflicted with one of the cancers we're going to talk about here in a moment, and you lived, worked, went to school, went to daycare within about a mile of the ETO facility, that's something attorneys take very, very seriously. Again, it doesn't mean you definitely got your cancer because of the ETO facility, but it's certainly worth a strong look by an attorney. From 1 to 3 miles out,
as you get further out, that still deserves a strong look. And again, we're talking about as the crow flies. And that would, again, especially be so if you lived, worked, went to school in the EPA model risk zone, which would be available online depending on which facility that you live, work, or go to school nearby. That would show whether the plume that is modeled by the EPA covers that area. Again, the plume is not a be-all, end-all piece of information, but it's a good starting point for making this analysis. And this is a difficult conversation to have because the C word, the cancer word, is one of the scariest words in our English language. But these are the kind of cases that are being brought against these commercial sterilizers and have been brought against, and people have prevailed. And so some of the cancers that you see linked to these sterilizers are non-Hodgkin's lymphoma, CLL, SLL, lymphocytic leukemia, multiple myeloma, breast cancer, especially DCIS or ductal carcinoma in situ. And the following cancers that I'm about to say now also should be reviewed, although they're less strongly correlated to ETO and would be much more expert dependent. Invasive ductal or lobular breast cancer, AML, MDS, mixed phenotype acute leukemia, and stomach cancer. Now, from 3 to 5 miles out from the facility, as the crow flies again, the case becomes much more fact dependent. You would want what lawyers call more stronger exposure facts. Many years in the area, significant daily presence, a cancer type that fits the ETO science extremely well, and the latency period that makes sense, which we'll talk about more here later in the video. Now, beyond 5 miles, the cases become much harder. Not impossible in some unusual situation. To put that in perspective, if someone lived, for example, 15 miles away, and maybe for a brief period, less than a year from a facility, that becomes very difficult and most attorneys won't review that. So the simple takeaway from this video is, if you live 0 to 1 mile away, very seriously talk to an attorney right away. If you live 1 to 3 miles away, and again, when I say lived, I'm talking about lived, worked, went to school, etc. Also take it very seriously, talk to an attorney, although it's obviously not as strong as living within 1 mile. And again, even if you live 3 to 5 miles, also talk to an attorney, but it's a very case-by-case basis. Those cases are not as strong, but can be very fact-dependent, depending on the individual facts and diagnosis in your particular matter. And then finally, if you live 5 or more miles away, again, lived, worked, went to school, again, very fact-dependent, unlikely, but still worth having a look depending on the facts of your case, especially as you get closer to that 5 mile mark as opposed to 10 or 15 miles out. But remember, radius is only the starting point here. The next question is very important too, and that is, where did the plume emitting from this facility actually go? Distance matters, but downwind distance matters more. A home that's 3,000 feet downwind may be more affected than a home that's 1,000 feet upwind. A school with an outdoor playground may unfortunately be affected more than a home that's closer, but not necessarily in the heart of the plume. And of course, a worker who's working in the building across the street 8 hours a day, 10 hours a day, is going to be affected more than a delivery driver who's just driving through there once a week. Now let's talk latency. Latency is a time between exposure to a dangerous chemical and the onset of the disease. In a toxic exposure case, the attorneys for the company or person that allegedly caused you to be exposed to this chemical, they're going to attack you on latency. They're going to try to argue that not enough time went by between the time you were exposed to the chemical that I caused you to be exposed to and the onset of your cancer. It takes years for these chemicals to damage your DNA and cause your body to produce cancer-causing cells. I'll give you an example of a case that probably would not go very far. Someone says, hey, I was first exposed in January, and then I was diagnosed with breast cancer in March the same year. That's probably not a strong ETO case, because in the case of breast cancer, it can take many years. We're really, in many of these cancers, it can take many years, but particularly in solid tumors like breast cancer, where we're looking at latency periods of several years, typically 5 years or more. But on the other hand, if someone lived, worked, went to school nearby a facility for many years during the production of ethylene oxide, and then the diagnosis in turn comes many years later, now lawyers and medical experts
they start paying attention to that. And believe me, there's no single universal latency period that would apply to every ethylene oxide case. I can't tell you whether if you had your cancer 2.6 years after first being exposed and Bob has his cancer 11.5 years after first being exposed, who is the better case, because a lot more goes into it. But it's important to understand if this is something that you or a loved one's dealing with, that they're typically, from a scientific basis, needs to have some years go by between first exposure and diagnosis of that cancer in order to scientifically prove that the cancer may have been caused by the ethylene oxide. An article in the Journal of the National Cancer Institute, which was discussing ETO and breast cancer, noted that after extended follow-up of employees through a NIOSH study, again, NIOSH is the National Institute of Occupational Safety and Health here in the US, which does a lot of these studies on employee health, found that breast cancer mortality associated with a 20-year cumulative exposure lag. And a nested case control analysis found the highest incident of breast cancer at the 15-year mark. So again, let's try to divide these into just simple buckets. Bucket 1, it's been under 2 years since you were first exposed to the ethylene oxide. That is probably a red flag. Not necessarily impossible, but you would need really strong expert support, especially for tumors that are solid, like breast cancer. Bucket 2, 2 to 5 years has gone by since your first exposure. This is more plausible, especially for the blood cancers like leukemia, non-Hodgkin's lymphoma, and others, but still highly fact-specific. Bucket 3, 5 to 15 years. Wide range, 5 years to 15 years since your exposure. This is where many lawyers start to take the timeline more seriously, especially for leukemia, lymphoma, myeloma, and even some breast cancer claims depending on the exposure intensity. And then again, we can go beyond 15 years to even bigger exposure lag times and time periods, which again can strengthen the case in some cases, or perhaps hurt it if you've been exposed to other cancer-causing or had cancer-causing habits in the meantime. Now let's explain what lawyers actually look at in a case that involves air pollution. First, the emission rate. How much of this offending chemical was being produced and emitted by the company on a daily, weekly, monthly, yearly basis? How many pounds per day? How many pounds per year? Was it constant or in batches? Were there peak release times? If so, during which times a year? Were there startup, shutdown? Were there times when the facility malfunctioned and perhaps filtration or other controls were not working for a period of time? Second, what was the source of the emission? Was the ETO released through a stack? In other words, like a chimney on top of the building, exhausting out the air? Or was it released through a chamber vent? An aeration room vent? Did it just dissipate out of a sterilization room? Did it leak under a door? Did it come out through the building's other exhaust systems? Or was there fugitive, unaccounted for emissions? Interestingly, in this context, the EPA's 2024 rule matters because the EPA specifically targeted some of the emissions that aren't necessarily coming out of the traditional exhaust stack on top of the building. Room air emissions, chamber exhaust vents, sterilization chamber vents, aeration room vents, all these what we call fugitive emissions that aren't coming out the traditional expulsion point. Then we look at something called stack parameters. And it sounds nerdy, I get it, but it's huge. EPA's Air Mod user guide looks at things like emission rate, release height, stack gas exit temperature, stack gas exit velocity, stack inside diameter. In other words, how wide was the pipe through which the gas came out? Was it thin or was it wider? That plays a role in the pressure created in order to get the gas expelled out of the facility. These are not academic details. This is all physics. They determine plume rise and dispersion. How high up is the chemical going when it leaves the facility? Going all the way up into the clouds and dispersing out into the atmosphere where it can't be breathed in by people? Or is it actually not going up high enough or being pulled back down by other atmospheric forces to ground level where it can then in turn be breathed in by innocent people? Give you a simple example. If a gas leaves a stack hot and fast, then there's a good chance it's going to rise higher and higher before ever coming down into a breathable space. But if it leaves a short stack, if it's not going that fast when it leaves, if it's not that hot, it may stay lower and create higher concentrations of a cancer-causing chemical in a space where an innocent person could potentially breathe it in on a repeated basis. That is stack momentum and buoyancy. Now let's talk about building downwash. When wind hits a building, it creates a turbulent wake on the downwind side. In fact, the EPA's own downwash white paper explains that a plume caught in that flow can be drawn into the wake and temporarily trapped in a recirculating cavity, causing higher ground level concentrations near the building than if the building were not there. And that is the kind of scientific detail that wins or loses cases. So when you see a facility on Google Maps, don't just ask, how far away is my house? That's important, but that's not the only question. What direction is my house from the facility? What direction did the wind usually blow? How tall was the building where they manufactured or produced or emitted this chemical? How tall was the stack or chimney or exhaust pipe where the chemical left? Was that stack near a wall or a corner of the building? Was the plume hot or fast, or hopefully both, as it left the building? Or was it too cool, too slow moving? Did my home, school, daycare, workplace, was it a commercial area where they had outside air intake into that building? In other words, some facilities pull in outside air because that's a Florida rule for HVAC systems. You have to bring in what's supposed to be fresh air into your building. But unfortunately, that's not always the case. So people who worked in the commercial facilities on a regular basis nearby, they have a stronger data point if they're inside a lot, because they can say, yes, I was inside the building, but my building brought in fresh air. And that fresh air in this case, if it was in the plume, was contaminated with ETO. Let's bring this to Florida. In Tampa, specifically Temple Terrace, American Contract Systems operated a commercial sterilizer, meaning a company that would sterilize medical equipment, at an address at 7802 East Telecom Parkway. The EPA identified that facility as contributing to elevated risk of cancer in the area because of the ETO emissions. Using data from before the company installed extra filtration in July of 2023, so basically from 2016 to July of 2023, they used data to determine that certain neighborhoods in that area were at elevated risk of cancer. Now again, does the EPA's document definitively prove if you got cancer and you live in that area that it was from ETO and American Contract Systems? Absolutely not. But that certainly is a good place to start. If you have been diagnosed with a certain type of cancer and you did live in that area, you should definitely be talking to an attorney. Now, notably, in July of 2023, American Contract Systems installed 3 what's called dry bed scrubbers in their facility that reduced the amount of ETO emissions from 5 pounds per day to 0.05, not 0.5, but 0.05 pounds per day, which is like a 99.8% reduction in the cancer-causing chemical. So let's pause on that. 5 pounds a day is 1,825 pounds in a year. Less than 0.05 pounds per day, that's about 18 pounds per year. 1,800 pounds before the scrubbers, 18 pounds after. So when the EPA tells you that those controls, those scrubbers, reduce the amount of the pollution by that dramatic of a percentage, that control technology, that filtration, and whatever word you want to use, that matters. And of course, the next logical question is, why did it have to wait until July of 2023 to be installed? What did the company know before that time period? What did regulators know? Were emissions controlled at all before July 2023? Were there tests being done on the stack that was emitting the ethylene oxide on top of the building? Were there building leaks so that the polluted air was getting out through some other method besides the stack on the roof? Were there filter failures? Were there failures in the way that reporting was done to the government by American Contract Systems? Were nearby residents, workers, parents of school children, were they warned at all? Now we have to understand that the science tells us this is not like if you were exposed on a single day or just a handful of times to this chemical that you're at risk. This is about long-term exposure. People, again, who lived, worked, went to school, spent 8, 10, 12, 24 hours a day in the area where this chemical plume was hanging out, for lack of a better word. But the EPA was clear that over a lifetime of inhalation, breathing in of ethylene oxide, that does indeed contribute to an elevated cancer risk. Now listen to those words. Contribute to an elevated cancer risk. Doesn't mean, yes, you will get cancer if you lived in the area from ethylene oxide. Doesn't mean that. But it does mean that it does increase your risk. And you can look at analogies like that when you do things that are dangerous, like drunk driving, right? Many people drink and drive and nothing happens. But what does drinking and driving do? It increases the risk that you're not going to be as good of a driver for a variety of reasons that could lead to more accidents. In Hillsborough County Circuit Court, which is the county in which Tampa is, there's been 19 cases filed since last fall for individuals who were afflicted with cancer that allege it was from ethylene oxide emitted by American Contract Systems. Those cases are still very early on. They will probably go on for many years. And again, these are allegations. These cases have to be proven. The defendants get to contest whether the folks that are plaintiffs, these folks were not exposed as much as they are alleging. They get to allege that maybe the cancer came from some other, aspect of their lives that was contributing to cancer. They get to allege that they weren't emitting enough ETO that caused that issue. They can look at the wind records. They can poke all these holes in the perfect chain that has to be built by the plaintiffs in order to build a case to be able to prove to a jury that it's more likely than not that the cancer this person's suffering with was caused by ethylene oxide that was emitted by, in this case, American Contract Systems. So a lot has to be proven to be able to hold American Contract Systems liable in this case, just like any other defendant in a case such as this. The same company, American Contract Systems, also had a facility in Fort Myers. And the EPA also had American Contract Systems' Fort Myers location on their radar. The address of the Fort Myers location is 11600 Adelmo Lane in Fort Myers, Florida. And it followed a very similar timeline as the Tampa/Temple Terrace facility, where the scrubbers were installed in July of 2023. These scrubbers that, again, reduce the amount of cancer-causing ETO that's being emitted into the air dramatically, from 5 pounds a day to 0.05 pounds a day. So after July 2023, there appears to be a lot less risk to the neighboring community. But again, the same question is going to be asked in Fort Myers, and is being asked in Fort Myers, as it was asked in Tampa. Why? Why is it taking so long? Why did it take so long? What did they know before July 2023? Florida is not the first battleground over ethylene oxide. The first time that the general public heard about ethylene oxide in terms of a big litigation lawsuit, the case that put ethylene oxide litigation on the map was out of Illinois. In September 2022, a Cook County, Chicago, jury awarded $363 million to a woman who alleged a company called Sterilizes exposed her to ethylene oxide for over 20 years. And that exposure led to her cancer diagnosis. The award included $38 million in compensatory damages and hundreds of millions of dollars in punitive damages. After that, Sterilizes agreed to pay $408 million to as many as 870 people with similar cancer claims. Now, to be clear, Sterilizes and its parent company denied liability and denied the operations posed any safety risk, and that the settlement was not an admission of liability. Georgia is another major ethylene oxide litigation state. The same company I just mentioned, Sterilizes, agreed to pay a $35 million settlement of nearly 80 lawsuits involving its plant near Smyrna, Georgia. Again, the company denied liability in that case and denied the emissions posed a safety hazard. And the AP reported that hundreds of related claims remain pending as of the time of this video. And then there's also litigation in Covington, Georgia. In 2025, a Georgia jury awarded $20 million in compensatory damages in a toxic chemical cancer trial involving ethylene oxide. In that case, a truck driver named Walker lived within 1.5 miles of the plant, and apparently through his occupation either did pickups or deliveries to the very plant that produced the ethylene oxide. He had non-Hodgkin's lymphoma, or NHL. So here's why these cases from Georgia and Illinois and elsewhere matter, because it's not just theoretical. Very similar companies to American Contract Systems have been held liable in a court of law, and there's been major settlements. Does that mean that will happen in Florida? No, it doesn't. There may be completely different facts once litigation reveals the facts behind American Contract Systems operations that completely absolves them. We have no idea. But certainly, given some of the litigation history and some of the things we know about ethylene oxide and what regulators and the general science public knew about the dangers of ethylene oxide, it's certainly worth investigating, because I can tell you, people deserve justice. And if there is a provable case for the residents, workers, children who lived, worked, went to school, played nearby, and they were afflicted with cancer because of it, then those people deserve justice. ETO cases are no longer theoretical. Juries have heard them. Companies have settled them. Major verdicts have happened, and the strongest cases are not built on vague fear. They're built on specific cancers, specific facilities, specific emission history, specific modeled toxic plumes, specific years of exposure, specific failures in control, monitoring, and disclosure. That's the difference between panic and proof. So let's get practical here. If someone thinks they may have an ETO claim near American Contract Systems Temple Terrace / Tampa location or their Fort Myers location, here's what you need to know. A serious lawyer, number one, is going to want a timeline. Not just, oh, hey, I lived in Tampa. They're going to know your exact address, when you lived there, how much time you spent there, how much time you spent outside, how much time you spent inside. What was your HVAC system like? What was your vacation schedule? Would you travel for months out of the year and not come back to your home? Did you work in the area as well as live there? Where'd your kids go to school? If you worked in the area as well, did you spend a lot of time outside in your lunch breaks, in the mornings for walks, on your breaks? How often were your kids outside when they were at school? What did you do before you moved into the area? Did you have any other cancer risk activities or genetic history or family history? Lots of questions need to be answered. We're going to leave you a link in the comments below to give you a whole set of questions to look at, so you can kind of get an idea of what specific things will be helpful to understand whether you may have a potential claim against American Contract Systems, or quite frankly against other commercial sterilizers around the country. And then a good attorney will overlay your timeline with the timeline from the commercial sterilizer about their ethylene oxide production schedule. When did they start producing ETO? When were the emissions uncontrolled versus being controlled with the dry bed scrubbers or some other control system? How often were stack tests performed? What was the emission rate per year? Were there any notices of violation by any environmental agencies? Were there fugitive emissions in this facility? Were there chamber leaks? Were there other complaints? Who knew? Who did they warn? Who stayed silent? And then, of course, in a case like this, you need experts. The court's not just going to take the lawyer's word for it. They're not going to take just the company's word for it. They want to hear from folks like an industrial hygienist, an air modeler, a toxicologist, an epidemiologist, a medical causation expert, sometimes an oncologist, sometimes a building or HVAC expert, sometimes a regulatory expert, sometimes a corporate knowledge expert. Who knew what within the corporation? Because the case, again, is not won by saying ethylene oxide is bad. The case is won by showing the person had a relevant cancer. They had a plausible latency period between the first time they were exposed to when their cancer was first diagnosed. They were in the plume often enough and long enough that the ETO could have negatively affected their DNA and, of course, ultimately caused cancer. The controls were inadequate at the facility. The facility emitted and produced enough ethylene oxide to matter to affect the community. Then exposure was the substantial contributing factor to that person developing that cancer. That's a much harder case, but also, if those facts line up, it's a much stronger case to hold the other party accountable. Let me be very clear. Not everyone who lived near a facility that produces ethylene oxide, or worked near there, or went to school near there, has a case, even if you were diagnosed with a cancer that we've talked about today. Not every EPA map means every person inside of it will be sick. So if you're panicking because you're watching this and you lived in the plume covered by the EPA maps, don't panic. And not every lawsuit will every allegation be proven. There's lots of these cases where the defendants win because the plaintiffs, the people who are sick, are not able to prove with evidence that their cancer or whatever disease they were afflicted with was most likely caused by whatever chemical was being produced by the company. Because the public has seen too many of these toxic exposure cases talked about in a dishonest way. One side says, there's nothing to see here. It's all just a bunch of people stirring trouble up and lawyers stirring trouble up. That's not true. There's real stuff going on here, and people need to be held accountable. But on the other end of this spectrum, it's not a case where we have an evil corporate giant trying to poison everybody, and everybody in the area is poisoned now. That's not true either. Both can be wrong. The truth is more specific and quite frankly more uncomfortable. Individual causation. In other words, being able to prove that a cancer was caused, or at least substantially caused, by ethylene oxide from that plant needs to be proven in each and every individual case. And you can imagine that kind of proof is difficult to come by. But that's not a weakness. That's how science and the law work and come together. The most important evidence in an ETO case is invisible. The gas is invisible, plume is invisible, the risk is invisible, the latency period is invisible, and for many people, the warning, if there even was one, was also invisible. But invisible does not mean unknowable. We can reconstruct emissions. We can reconstruct the wind. We can model the plumes of chemical in the air. We can map homes and schools and hotels and daycares and other businesses. We can compare diagnosis dates, latency periods, and first exposures. We can look at what changed after scrubbers or filtration were installed at these companies. We can ask the question. We can ask why. Why weren't these scrubbers or filtrations installed earlier? That's why ETO litigation is not just about chemistry. It's about accountability in the space between the factory and somebody's front door. And so if you lived, worked, went to school, your child went to daycare, you spent significant time otherwise in an area where the EPA has modeled a risk zone for ethylene oxide exposure, and you've been diagnosed with a cancer like leukemia, non-Hodgkin's lymphoma, multiple myeloma, lymphocytic leukemia, or breast cancer, the question is not whether you should panic. The question is whether your exposure history should be reconstructed carefully. Because in these cases, the truth is not in the smell. There usually was no smell. The truth is in the records.